The court, being duly advised, finds the defendant is in imminent danger of serious bodily injury or death.
Fuck, I always do that. Hi, everybody. Thank you for being here. We have a new defense filing, and I figured I would go live and tell nobody, and we can read it together. So I'm going to say hi to my friends first. Hello, woman. I know. I literally think that I've done it every single live that I've done. Hi, Mar. Hi, Luke. Hi, Wheat. Hey, Criminal Network. You crack me up. Has anybody read it yet? God. Has anybody in the chat read the response yet? I think they filed it like around like 2 something this afternoon. Page 6. Cool. Oh my God. So I guess let's read it together. Okay. So this is a memo of law in support of admission of evidence of alternative theories of the crime and third-party perpetrators. So this is a response, essentially, to the state, Nick McClelland, filing his motion in limine, requesting to exclude basically every single third-party suspect and everything to do with the crime at all. Bean has almost finished it. Cool. Hi, Bean. Okay, here we go. Comes now, Richard Allen by counsel, and provides this memorandum of law in support of admission of evidence of alternative theories of the crime and third-party perpetrators. Mr. Allen has a constitutional right under the 6th and 14th Amendments of the United States Constitution and Article 1, Section 13 of the Indiana Constitution to present evidence attacking the credibility of the prosecution's case, undermining the believability of the prosecution's witnesses, identifying third-party suspects, and establishing Mr. Allen's theory of the case. This right is the cornerstone of the adversarial process and essential to a fundamentally fair trial, and denial of this right constitutes structural error, which is, hi, Mandy. So structural error is a reason that a lot of criminal cases that are adjudicated through a trial or whatever end up back in the Court of Appeals over something called structural error, which is like a blatant misapplication of law, basically, I think is how I'm understanding it. So it's like a little, like, I feel like a little nod to like, don't commit structural error, because then we'll be back in the Court of Appeals. Okay. Whether rooted directly in the Due Process Clause of the 14th Amendment or in the compulsory process or confrontation clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. This right is accomplished through the right to offer the testimony of witnesses and to compel their attendance at trial. It is necessary for both the accused and the prosecution to present their version of the facts to the jury so that it may decide where the truth lies. Just as an accused has the right to confront the prosecution's witnesses for the purpose of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of due process of law. When the prosecution seeks to prevent an accused the opportunity to present other versions or possibilities regarding the alleged crime, either through cross-examination or his own witnesses and exhibits, they're urging the trial court to commit not only an evidentiary error, but a constitutional error from which prejudice is presumed. And then they cite this case, and they say, in this case, holding that the burden switches to the state to rebut the presumption by showing that the error was harmless beyond a reasonable doubt. Similarly, exclusion of evidence tending to show that somebody other than the accused committed the charged crime is inconsistent with substantial justice and therefore cannot be deemed harmless error. So this case that they cite a lot throughout, it's Allen versus the state. It's obviously not this Allen, but just, because it's going to come up a lot. Thus, the question becomes, what type of evidence is so critical and so unique to Mr. Allen's defense that the United States and Indiana constitutions, above and beyond the Indiana rules of evidence, require its admission? The Indiana courts have answered that question by reversing cases when the excluded evidence challenged the credibility of the state's investigation and witnesses, presented an alternative exculpatory explanation of the state's evidence, or showed that somebody else could have committed the crime. At the hearing, and this is referring to the July 30th, 31st, and August 1st hearings. I don't know which one of them was motion in limine. I think the first one. At the hearing on the prosecution's motion in limine, Mr. Allen presented evidence that the murders of Abigail Williams and Liberty German had ties to Odinism and were ritualistic. Mr. Allen also presented evidence that third parties are linked to the murders. The prosecution seeks to exclude, quote, evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 101. Nick cites Rule 101 a lot. He really likes that rule. The prosecution further requests an order to exclude testimony or evidence concerning A, Odinism, B, cult or ritualistic killing, C, Brad Holder, D, Patrick Westfall, E, Johnny Messer, F, Elvis Fields, G, Ned Smith, H, Rod Abrams, I, Kane Klein, J, Jerry Anthony Klein, and K, Ron Logan. The prosecution's requests seek to limit Mr. Allen's ability to present a defense and, if granted, violate Mr. Allen's rights pursuant to the 6th and 14th Amendments of the United States Constitution and Article 1, Section 12 and 13 of the Indiana Constitution to confront and cross-examine witnesses and to present his defense. Mr. Allen is entitled to present evidence pursuant to the 6th and 14th Amendments and that the crime had elements of Odinism and ritualistic killings. Demand that the jury hear all versions and possibilities regarding the alleged crime. Holding that it was a constitutional violation to prohibit the defendant from introducing a suicide note near the body and allowing the state to introduce the death certificate stating homicide. This is my favorite quote in the entire motion. It says, "The state cannot take advantage of the inculpatory conclusion, but prohibit the defendant from placing the exculpatory conclusion before the jury. You can't just provide and and admit evidence that supports your theory, Nick McClelland, and exclude and prohibit all evidence that supports the defendant's innocence. You cannot do that. You cannot admit 15 confessions that support Allen's guilt and exclude the 40 plus other confessions that exclude him from being involved in the crime. You can't. It's just not okay. It's not how it works. And then they cite Turney versus State, which held that otherwise inadmissible evidence that a third party molested a victim was admissible as an alternative explanation for the victim's injuries. So this case was appealed, and the evidence that was not admissible. Anyway, I'm not going to try and interpret that. In this case, the prosecution argues that Richard Allen, acting alone, killed Abigail Williams and Liberty German. However, the evidence from the location where the bodies were found strongly suggests that more than one person was responsible for these murders. Former Indiana State Police Detective Kevin Murphy testified that it was always the belief of law enforcement that there were between 2 to 6 people involved in the murders. That was a new number for me. I don't know if we've read that before, but that's, 2 to 6 people. If the prosecution's argument is that Richard Allen acted alone, and there are alternative theories that the murders were committed by more than one person, then who are the additional people involved in killing Abigail Williams and Liberty German? The answer is that there are third-party suspects who have not been charged and who have no ties to Richard Allen. This leads to the conclusion that Richard Allen is innocent and that other individuals acting together killed Abby Williams and Liberty German. Dr. Dawn Perlmutter, the director of Symbol Intelligence Group and adjunct professor of forensic medicine at Philadelphia College of Osteopathic Medicine, who trains federal, state, and local law enforcement agencies, testified that the murders were committed by individuals with ties to racist Odinism, sometimes known as Asatru, if I said that wrong. Odinism and Asatru are polytheistic ideologies involving the worship of Nordic pagan gods, including Odin and Thor. These ideologies are nature-based ideologies, and their rituals generally take place outdoors, incorporate natural elements, and are typically performed near natural bodies of water. Both ideologies incorporate the use of runes, which are marks of mysterious or magical powers. Magical powers. Runes take on additional magical powers when charged by blood or when 2 or more single runes are coupled together to create a bind rune. It's not funny. It's not funny. Both ideologies also incorporate magical thinking. Dr. Perlmutter further testified that while Odinists have general shared symbols, such as Odin's hammer, as they splinter off and form different kindreds, they often develop their own symbols and rituals. Social media has been a large part of this development as it allows individuals access to a wide range of interpretations, symbols, and ideas relating to Asatru and Odinism. Dr. Perlmutter testified that the murders of Abby and Libby meet all of the elements of a ritualistic killing and was a, quote, textbook ritualistic killing. The elements of a ritualistic killing include, and actually Courtney did a really good job of taking notes on this part because some of this we had heard from her from the hearings. But number 1, the location of the crime. Dr. Perlmutter testified that Odinism and Asatru are nature-based ideologies. These murders took place outdoors in a clearing in a wooded area near a body of water. Dr. Perlmutter testified that in Odinism and Asatru, clearings can be a location of a sacred circle where rituals and sacrifices take place. She further testified that it's important that the murders took place near a body of water, as water is often used for purification prior to rituals or sacrifices. Date of death. Dr. Perlmutter testified that often rituals and sacrifices take place on important dates. She testified that Valis Blot is a sacrificial feast day honoring Odin's son Valis. This begins at sundown on February 13th and ends at sunup on February 14th. Liberty German and Abigail Williams disappeared on February 13th and were found on February 14th. Cause of death. Dr. Perlmutter testified that ritualistic crimes are most often committed by sharp force injury to the neck, and that slitting the throat is indicative. Slitting the throat is indicative of sacrifice and an initiation ritual. Both girls were killed in this manner. Now, this footnote, or not footnote, but this citation here says Defense Exhibit G, G, and HH, which are the autopsy reports that were performed by Dr. Roland Core. He was the pathologist, the doctor that did the autopsies of the girls. And he's very, very, or I think I don't know if he's not deceased, but he's retired, I think. High yellow. You definitely know. He's retired, I think. And he's done like probably approximately 1 billion autopsies. Murder weapon. Dr. Perlmutter testified that ritualistic crimes are often committed with ceremonial knives. The weapon used to kill the girls was a knife. Did everybody hear that? The weapon used to kill the girls was a knife. Citation: Defense Exhibit GGHH, autopsy reports of Dr. Roland Core. Moving on. Symbols at crime scene. Dr. Perlmutter testified that in ritualistic killings, symbols, including runes, are often left at the scene. In this instance, there is what can be interpreted as a lagus rune, painted or transferred to a tree with Liberty German's blood. Thank you, Courtney. Dr. Core is retired and very well respected. Sending them to him for an autopsy was the only thing they did right. Fabulous. Excellent. Good. This tree is located near the area where the girls' bodies were ultimately found, on the edge of the clearing. Additionally, Dr. Perlmutter testified that the sticks and branches laid on the bodies appeared deliberately and intentionally placed, in particular arrangements which would have meaning to the individuals committing the crime. FBI Special Agent Nicole Robertson testified that when she was searching the home of Ron Logan, she was looking for evidence of runes and anything Nordic due to the placement of sticks on the girls' bodies. And that is from the deposition taken of Nicole Robertson on page 75. These are long depositions. The emails between the FBI and the state police superintendent, Doug Carter, all provide evidence of the belief by law enforcement that the evidence left behind at the crime scene, including sticks found on the girls, supported the possibility that the killers were Norse paganists. Defense Exhibit E. Body disposition. Dr. Perlmutter testified that in ritualistic killings, bodies are often moved and positioned in a fashion that is not a counter-forensic measure. In other words, the bodies are moved and positioned in a manner not consistent with someone who's trying to conceal the bodies. So they're not they're not putting sticks on the bodies and leaves and covering them up to like hide them. They're doing it for another reason. Dr. Perlmutter further testified that the bodies are often positioned to include the arrangement of natural objects. In paragraph 6 of her affidavit for probable cause for the search warrant for the home of Ron Logan, FBI Special Agent Nicole Robertson testified it was her belief that Libby German and Abigail Williams' bodies had been moved and staged. Major Cicero of the LaPorte County Sheriff's Department also testified at the hearing that Liberty German's body was dragged around the crime scene and that Abby Williams was moved from side to side. Additionally, it is evident from the crime scene photo identified as Exhibit FF that sticks and branches were deliberately and intentionally arranged on the bodies. Major Cicero testified that the sticks and branches covered 3% of the girls' bodies. He further testified that there were many leaves and sticks in the area which could have been used to conceal the bodies if that was the intent of the killers. Fiend, I don't know what this means, but I can't wait to see it. Creeper. Holman. Oops. Holman and Liggett should have known what Nicole said. Yeah, I think they probably did too, huh? Holman knew. He told multiple people back in the day that there were Odinism signs at the scene. Yeah, he said it looks like Odin. Dummy. Yeah, I agree. Okay. Atypical blood pattern. Finally, Miss Perlmutter testified that there's often atypical blood patterns identified in ritualistic killings. She identified the blood pattern on Libby German's face as an atypical blood pattern. This abnormal blood pattern on Libby's face was also identified by Major Cicero. So Cicero was a state's witness at the hearings. And the fact that the defense is bringing the state's witness, his testimony, into their motion is really good, because it's saying like, hey, this expert that the state's using actually is supporting the things that we're saying. Yeah, criminal network, they said on Libby's face, which is really sad. And I don't know what they mean by an abnormal blood pattern. It's startled me. Hi, DB. You can come in whenever. I don't know what that means.
Getting too closer to the truth. Please pull over, ma'am. Please pull over.
Come back with a warrant, sir. Signed by a judge other than Diener. Oh, and he's gone. Okay. Well, so moving on. Yeah, I don't know what an abnormal blood pattern is on her face. So could that be a symbol? Maybe. Or on her forehead, maybe. Yeah. Word. Box cutters and undoing remorse, finding God after 2 months in jail. At least 3 liters of blood.
What do those guys want? Jesus.
I don't know. They're always bothering me.
They're right outside. They wouldn't let me in for a second.
Geez, sorry about that.
Oh, it's okay.
Okay. Glad you made it. So, Mr. Allen has a constitutional right pursuant to the 6th and 14th Amendment of the United States Constitution and Article 1, Section 12 of the Indiana Constitution to present evidence describing the area where the bodies were found, the manner in which they were found, and to provide an explanation for said descriptions. He further has the right to present. Okay. He further has the right. Thank you. He further has the right to present evidence flowing therefrom that the individuals who killed Abigail Williams and Liberty German were followers of Asatru and Odinism, and that the murders were part of a ritualistic sacrifice. The 6th and 14th protect Mr. Allen's right to challenge the manner, quality, and thoroughness. Oh, this wasn't my other favorite. Protect Mr. Allen's right to challenge the manner, the quality, and the thoroughness of the investigation, to inquire about law enforcement's failure to consider third-party suspects, and to present evidence of a biased investigation. So that's really good, because actually DB and I was reading earlier, the motion that the prosecutor filed back in when was it? I don't remember when it was, or maybe it was a response to the defense's request for discovery. But
yeah, it was.
It was a response, right?
January 2023, I believe, and it was just like them objecting to all of or saying that they're going to provide it.
Yeah. So this is something that defense attorneys and the defendant can do at a trial, is, and I think we saw it in the Karen Reed case a little bit. I think Judge Bev excluded some of it, but it usually gets in one way or another, and that's usually through examining witnesses and cross-examining them, especially when the witnesses are investigators and law enforcement. But the defendant has a right to challenge the quality of the investigation, basically. And if there are these like glaring, substantial issues that would cause a reasonable person to doubt the veracity of the evidence that the state's presenting, you're allowed to present that. So, yeah, and that was the defense filed a motion for Indiana rules of evidence. It's called like 401 and 402. It's not like specifically related to the crime, but it's relevant because it's indirectly like related. Anyway, Mr. Allen has a fundamental right to impeach the credibility of and present the bias of any witness, including law enforcement. Quote, a witness's bias, prejudice, or ulterior motives are always relevant at trial in that they may discredit her or affect the weight of her testimony. It has been well established that law enforcement, like all humans, can suffer from confirmation bias and tunnel vision. In other words, a detective or an officer may search for and interpret evidence in a manner that confirms his or her existing beliefs. And actually, Janie sent me all of the like footnote, the literature that they cite, and I've started reading some of it, and it's very interesting. So I'll share some of it on the Google Drive after this if you're interested. But in this matter, Mr. Allen's evidence is that law enforcement failed to properly investigate third-party suspects and failed to consider alternative theories to their timeline. In this case, members of Unified Command failed to follow up on leads and investigations of Assistant Police Chief Todd Click and Indiana State Police Detective Kevin Murphy, such as the failure to perform an extraction of Brad Holder's phone.
Wait, weren't those guys like defense investigators or something?
Todd Click and Kevin Murphy?
Yeah, they were. Those were just like internet cranks, right?
Yes, they're Reddit regulars.
Oh, okay.
Yeah, that's who they are. Investigate the alibi of Patrick Westfall or Elvis Fields and the failure to seek warrants to search the homes of those individuals. Unified Command did not consider any fact that did not fall into their timeline that the girls were murdered between 2:14 and 3:30 p.m. on February 13th, 2017. Unified Command failed to investigate why Liberty German's cell suddenly connected to the cell phone tower at 4:33 a.m. on February 14th, 2017, after not connecting to the tower. Oh my God, it scared me. Okay, I can't look. After
Sorry,
not
I just pressed the buttons over here accidentally.
Yeah, you're good. It happens. It's fine. After not connecting to the tower from 5:44 p.m. on February 13th until 4:33 a.m. on February 14th.
I gotta crop that one a little. Oops, sorry.
Do you want to, please?
Excuse me?
You want to, is there something you want to share with like the class?
Was I unmuted?
No, you're fine.
Oh.
Indiana State Police Detective Jerry Holman testified that there was no evidence that Richard Allen returned to the location where the bodies were found after 3:30 p.m. on February 13th, 2017. Something happened at 4:33 a.m. on February 14th that caused Liberty German's cell phone to suddenly connect to the cell phone tower, and it is logical to believe that whatever caused the phone to connect was the result of actions taken by third-party suspects. Yeah. This evidence goes to the very heart of the thoroughness of the investigation into the deaths of Abby and Libby. Mr. Allen's constitutional rights require that this evidence be admitted. Protect Richard Allen's right to present evidence that someone else committed the crime. Evidence is relevant when it has any tendency to make the existence of any fact that's of consequence to the determination of the action more probable or less probable than it would be without the evidence. Evidence which tends to show that somebody else committed the crime logically makes it less probable that the defendant committed the crime, and thus meets the definition of relevance in Rule 101. In order for a defendant to admit evidence that a third party is responsible for the crime, the defendant must show some connection between the third party and the crime. What Nick McClellan is suggesting is that they have to have DNA. Yeah. Was that your mouth? Did you do that with your mouth, DB?
Yes, I do everything with my mouth.
Yeah, I've heard that about you. So page 10. When the state excludes competent, reliable evidence that is central to the defendant's case, his constitutional right to present evidence is abridged. They cite Joyner v. State a lot. DB, do you happen to be familiar with Joyner v. State?
No, but I'm a big fan of Joyner Lucas.
Yeah. Okay. Cool. Indiana courts have found the following evidence to be competent and reliable evidence central to the accused defense that somebody else did it. For example, in Allen versus State, The defense provided a reconstruction of the crime and testimony that another person made statements linking himself rather than the defendant to the murders, which should have been admitted. Evidence that a married man was having an affair with the victim, worked at the same place as the victim, the defendant had sexual relations with the victim the night before the murder, lied to his wife about his whereabouts, had an argument with the victim on the last day she was seen alive, and lied about his time card at work the day after the murder was admissible. In Rohr v. State, evidence that a prior beating of a child victim by the mother, not the defendant, caused the victim's extensive injuries was admissible. Evidence of a newspaper article with a picture of a person wanted in connection with burglaries in the area who resembled the defendant was admissible. Understanding that evidence of third-party suspects is relevant, the question then turns to the standard the court must utilize in determining whether the third-party evidence is admissible. This, in my opinion, is where Judge Gull abuses her discretion, perhaps, in my opinion, when the court gets to decide the standard in determining whether or not something is admissible, whether or not a hearing, the burden to prove a Frank's hearing is necessary, has been met. Like, these are all things that Judge Gull, I think, uses or abuses her discretion, like her ability to, I don't know how, feel like I'm not saying that right, but like, there's no clear-cut rule book or guideline as to whether something's relevant or not. So you have to kind of like use your like logic and reason, and the burden for a Frank's hearing, for example, according to Judge Gull, has not been met. Whereas we know that like Frank's hearings have been held with far less evidence presented. So anyway, moving on. Not about Frank. We're not franking right now. Although this did feel kind of like a Frank's 2.0. They were like, okay, if you're not going to let us like have our hearing, then we're just going to keep we're just going to like haunt you with the information. As the Indiana Court of Appeals has stated, sorry, where's her bar? Her bar is, I was going to say her bar is in hell, but that would make it easy. I don't know where her bar is, woman. To be admissible in a criminal prosecution, evidence that a third party's committed the crime with which the defendant's charged need not show substantial proof of probability that the third person committed the act. It need only be capable of raising a reasonable doubt of the defendant's guilt. While a criminal defendant may present alternative perpetrator evidence at trial in order to cast doubt on the defendant's guilt, the defendant must first lay an evidentiary foundation to establish that the alternative perpetrator evidence has an inherent tendency to connect the alternative perpetrator to the actual commission of the charged crime. Done. Like, they did that 1.5 billion times. Like, that, at least that has been achieved, in my opinion. In my opinion. Not a lawyer. Here, Mr. Allen's evidence of third-party suspects falls well within this category of competent, reliable evidence, central to his defense that he is innocent and that other people committed the murders. Mr. Allen's evidence has an inherent tendency to connect third-party suspects to the commission of the crime. Dun, dun, dun. Third-party suspects. Brad Holda. Mr. Holda. How do you think he's doing?
Sorry, wrong horn. That horn wasn't the one you were looking for there.
Oh. Sorry. Can you get the one I just did? Can you acquire that somewhere?
Can you do it one more time?
Dun, dun, dun.
Let me see. Is this it? I swear to God, I hear that every hour, every 5 minutes. I hear it and I'm like, wait, is that no? It's just in my head. It's called tinnitus.
Oh, sorry about your tinnitus. If you make my dog bark,
oh yeah.
If you make my dog bark, I will drive to where you are, and then you know.
I dare you.
Yeah. Literally, don't. I'll be so pissed. Okay. So
Sit down right now.
Yeah, he's thinking about it.
lay down. Everyone just needs a little uncle, little fatherly.
I don't think that would help. I don't know what he needs. An exorcism. Okay. Brad Holder, the father of Logan Holder, who was Abigail Williams' boyfriend at the time of the murders. Oh, God.
There's a sound called the keyboard. My bad. Never mind.
DB's multitasking on his ASMR channel. Okay. Law enforcement identified Brad Holder as a suspect by February 17th, 2017, 3 days after the bodies were discovered. Law enforcement received several tips that Brad Holder was the man in the video found on Liberty German's cell phone, purportedly taken at the south end of the Monon High Bridge at 2:13 on February 13th, 2017. Yeah, seems it. In his first interview with law enforcement on February 17th, 2017, Brad Holder told officers that he had never met Abigail Williams. In his second interview with law enforcement on August 30th, 2023, Brad Holder claimed that he had difficulty remembering which girl Logan dated, despite the fact that the girl Logan dated had been involved in a high-profile murder case. In the second interview, Holder now remembered that he had supervised one date between Logan Holder and Abigail Williams. That sucks for them. Can you imagine?
Wait,
Brad?
did you guys just hear that?
No, I didn't hear anything.
That's so weird. Once I muted myself, I guess I didn't actually mute.
It was not. You were not muted. No, friend, you were not muted.
I would like to apologize to everybody.
It sounded like somebody was being like violently throttled. Yeah.
Yeah, that's really not good.
I hope they're okay.
Apologies.
So Brad Holder chaperoning a date. That sounds like fun for everybody involved, right? I lost my place. Oh, Brad Holder then told a third different story as to how many times he'd met Abigail Williams when he was deposed on May 2nd, 2024. In his deposition, Brad Holder claimed that he had met Abby Williams twice, including once at a third party suspect's house, Pat Westfall's house. It's also important to note that Pat Westfall never admitted to the police that Abby had been to his house. Richard Allen has a right to have the jury consider the following about Brad Holder's second statement on August 30th, 2023, and whether his second statement and his deposition 9 months later, both providing different accounts of Holder's interactions with Abigail Williams, tend to show that he's a third-party suspect. I love a parenthesis inside a parenthesis. How do you feel about that?
It's almost as good as a tangent instead of a tangent.
Yeah. A what?
Which I'm really known for.
You are.
A caveat inside of a caveat. Hey, is it really a home or is it a house over there at the old Westfalls?
It's a, you know what? Yeah.
More of a house.
A house. It's definitely a house and not a home. My bad. That's a house. Should I read all of this?
Yeah, you're doing great.
Okay.
Don't do that again. But other than that,
I'm gonna do it again. Nested parentheses. I like that. Are a neurodivergent love language. Okay, well, I'm giving myself away. I do like them though.
What about the M dash? The double dash?
That turns into a long dash?
Yeah.
Yeah, I love it.
What is that considered? Is that part of the
superior?
neurodiverge?
I don't know if it's neurodivergent. I just know it's superior to like the semicolon. I used to be really into the semicolon though. And then I was like, why am I like, it's not enough.
Now you're just like really into not capitalizing the first letter of each sentence.
You know, I wonder if that's no, that's not a neurodivergent thing. I think that's a something else thing.
It's a different thing. Yeah,
that's a different
I think
thing.
More on the personality cluster side of things.
Interesting. Okay. I think I've heard that somewhere before. Okay, number 1. I know why Andy et al. Do this, the numbered thing. Like, I do think it's effective. But it's like, as you're reading it, you're like, my God. Knowing the hotkeys for NumDash is definitely not it. Yeah. Woman. A square bracket? Interesting. I only use the square bracket when I'm like paraphrasing or like, I don't know if I'd ever use it anywhere else. Where else would you use it? Luke. Mr. Luke. Weatherholder lied in his first interview on February 17th, 2017. Am I on the right page? Yes. To inoculate himself against being a suspect by denying having met Abby Williams. This is inconsistent with his statement on August 2023 when he stated he had never met Abby Williams, and with his deposition testimony that he met her twice. The validity or lack of validity of Brad Holder's initial claim that he'd never met Abby in his February 17th, 2017 interview, 3 days after she was found murdered, but then somehow was able to remember 6 years later when interviewed on August 30th, 2023 that he had in fact met her one time. The likelihood that in 2023, Brad Holder, did my video go out? I mean, it doesn't matter. Can you still see me though?
Nope, I can still see you and I can still hear you.
Okay, I'm not gonna worry about it. The likelihood that Holder's ever-changing stories of meeting Abby Williams, including the last story that he met her twice, once at Pat Westfall's house, is indicative of a man who can't keep his stories straight and only changes his stories because he's unaware of law enforcement's evidence of those meetings, causing Holder to step closer to the truth with every account he tells.
Wait a second. Isn't that a lot of people's criticism of one Mr. Allen?
What?
That he was being inconsistent, but he was trying to come forward because he didn't know law enforcement's actual evidence.
Yeah.
So he was kind of like, doing the camel casing his way through the case a little bit.
Yeah. I think so. Yeah, but that doesn't count. I'm on 4 or 5. 5. Why would Pat Westfall choose to not tell law enforcement that Abby Williams had been to his house, as Brad Holder claimed in his deposition? And does such omission show that Westfall was concerned about being connected to Abby Williams? In the course of the investigation, law enforcement found that Brad Holder posted many pictures of runes on Facebook and discussed their symbolism and magical powers. His Facebook posts indicate that he believes in the magical power of runes. How come? Oh, there we are. Okay. Hi, True Grit. Welcome, my friend. Okay. Revealing are Brad Holder's own words in which he admits that runes hold magical properties. Brad Holder liked a post describing an outdoor sacrifice with a rune painted in human blood on a tree. Abuse of discretion standard.
Abuse of discretion standard is one of the 4 typically standards of review you see in criminal cases. These standards are on a scale of deference, meaning the appellate court can give almost 1/3. Sorry, I'm trying to work on my Travis because Criminality's gonna do a transcript read of one of Travis's latest cases, and I'm gonna be playing Travis.
Are you really?
I am.
You have some work to do.
I do, don't I?
You have some work to do. You gotta brush up on that.
Oh,
Cleveland
Rock. I am Timotei Chalamet.
Timotei Chalamet.
2/3 total deference to the trial court's decisions and findings, to giving almost no deference to the trial court. This is me playing Travis, playing Nick McClelland.
Awesome and shocking. Interesting. I can't wait for 3 of 3.
Yeah, 3 of 3 is gonna be good, I think. 2 of 3 looked a little short. Oh, Fiend, I don't do well on spice, let me tell you. It gives me acid reflux. Oh, did you mean K2?
The weirdest video came up on my. The weirdest video came up on my algorithm today. Would you like to hear what it was while we're waiting for 3 of 3? It was.
No, it's okay.
Okay.
No, go ahead. Sorry.
Okay. It was a Vice, Vice something, one of like the Vice shows, and it was basically. Do you remember that guy from like the 2010s? Shut the fuck up. From like the 2010s, who would do videos of like, this is me driving on salvia. This is me gardening on salvia. This is me changing a tire on salvia.
I'm doing salvia.
Do you remember him?
I'm on salvia now. No, I don't remember that. Was that real?
Yeah, he was like major popular, like millions of views, and all he would do is he would like be like, he would try and do just normal like tasks, and then he would like take a bong hit of salvia and then like try and do the task, but instead he would just like, Travis, where's 3 of 3?
We're doing bong hits, man.
DB, did you just get a new audio pack or something? Like a new?
Yeah. No,
Yeah?
my mom actually got this for me.
Your mom got it.
1994
Yeah.
at a garage sale.
Yeah. It's awesome.
Yeah. Let's see.
I think,
this
okay, well,
first.
anyway.
Wait. Ba-ba. This is. We're gonna play. Okay, my bad. Go ahead.
You just changed the mood though with that one, so. Blue light special from Kmart. Not Timothy Chalamet. Cleveland. I like your style. I like it a lot.
He's bigger and manlier than me.
He just seems brittle to me, you know. I get the appeal, but he just feels like I'd hurt him, and I'd do it.
Yeah, he'd whoop my ass. Let me tell you.
I'm sure he would, but I would just hurt him, and then I'd feel bad about it, and then it would ruin everything. Isn't salvia a plant in the aniseed family? I know it's a plant. I learned that today watching a 7 to 10 minute Vice video about this guy who would do salvia. I'm certainly not recommending it, or it's not smoked. I don't know how he put it in I don't know how. I'm pretty sure, I think stoners can smoke anything. I don't know. It was in a bong. He was doing bong hits of salvia somehow.
Speaking of a plant, Fiend's in here.
Hey, Fiend. I should keep reading, right?
Yeah.
Okay. Brad Holder believes in the power of magic. So goofy. I know it's not going to be goofy like at a trial when they're presenting it, and
Right.
Oh, hello, Tech Death. How are you? Thank you,
Mr. Death.
thank you, Luke, so much. Thank you for that disclaimer. My legal is here. Okay. Brad Holder believes in the power of magic. If you didn't hear that.
That's a deep cut. Guys, that's a real deep cut. If you know, you know.
I haven't heard that in a long time.
Oh.
Wow.
Even that sounded better though, because it was like an actual. Oh.
We're almost halfway. I have so many more pages.
This is called slap.
Okay. DB.
Yes.
Yellow. Jeez, how dare. I smoked a bowl in front of a cop driving by today. They just went legal Tuesday. Congratulations, Cleveland. Congratulations. I love when like the law catches up with fucking society. All right, Brad Holder believes in the power of magic. In blood, as it relates to magic. This is evidenced by his Facebook post, as well as Amber Holder's testimony that Brad Holder intentionally cut his hand and allowed the blood to drip on his Odin altar. I'm gonna skip. We're gonna skip. We're gonna go to the next section.
Yeah.
Brad Holder's, because it's like the same, a lot of the same. But I just do want to get to, this feels newish and relevant. Brad Holder's alibi is in question because of a 4:33 a.m. phone activity on Libby's phone. Detective Jerry Holman testified that Brad Holder had an alibi as he left work at 2:45 p.m. on February 13th, 2017, and was 40 minutes away from the Monon High Bridge. First Sergeant Chris Cecil of the Indiana State Police testified that the phone ultimately found under Abby Williams' body did not receive any SMS messages from 4:06 p.m. on February 13th until 4:33 a.m. on February 14th. 12 hours. This suggests that Libby's phone was not connected to his cell tower at that time. Law enforcement's claim is that the phone had remained under Libby German's body from around 3:30 p.m. on February 13th until it was found around noon on February 14th. I thought that was a typo at first, but remember, the state did claim in the probable cause affidavit for the arrest of Richard Allen that the phone was found under Libby, which is not true. It was found under Abby. There's just an error. It happens, but I believe that's why she put it here, because law enforcement did claim that. However, cutting against that theory is the fact that a police report references Sergeant Mitchell Blocher's belief, Blocher, that the phone, as of
I think it's Blocher.
Blocher, okay. Sergeant Michelle Blocher's belief that the phone, as of 10 p.m. on February 13, 2017, was either no longer in working condition or that it was out of the area. We know from Chris Cecil that the phone was in working order because it connected to the cell tower at 4:33 a.m. on February 14th, 2017. Therefore, the police report supports the fact that the phone was out of the area for a period of time. In further support, the phone was out of the area is the fact that from 5:44 p.m. on February 13th until 4:33 a.m. on February 14th, 2017, the phone in question did not connect to the tower in spite of law enforcement's claim that the phone had never moved from under the body of Liberty, from under Liberty German's body from roughly 3:30 p.m. on February 13th until the girls were found around noon on February 14th. Liberty German's phone received no text messages from 4:06 p.m. on February 13th until it suddenly received 15 messages at 4:33 on February 14th. It defies all logic that 15 individuals suddenly sent text messages to Libby at 4:33 a.m. on February 14th, 2017, when she had been missing for over 14 hours. When Liberty German's phone once again connected to the tower, as Chris Cecil finally admitted during his testimony, all of those messages awaiting Liberty German's cell phone to connect to a tower finally matriculated onto Libby's phone at 4:33 a.m. I like the word matriculated.
Me too.
It's a good one. Okay. The simple explanation is that somebody who was at the scene turned on the phone at 4:33 a.m., causing the phone to connect to the tower once again at 4:33 a.m. Jerry Holman testified that in law enforcement's theory of events, Richard Allen never returned to the crime scene after he left at around 3:30 p.m. on February 13th, 2017. Therefore, yeah, I know. We're going to start being creative, doing some more creative things to draw an audience.
To all who shall see these presents greetings. We're going back in time.
You're going way back in time tonight. You're taking us like way back. For a second, I thought you were like slurping a drink, but no, it's horseshoes. And I was gonna be like, sir. Nice.
Always, why don't you get up here and talk about it?
Yeah, sure. Yeah, fuck this motion. Come on up. I'll just go ahead. Patrick Westfall. Do we want to read about Patrick Westfall?
Yeah, go ahead. Did I say Nick Westfall? Oh, never mind. His
Um,
son Nick.
Okay. Brad Holder and Patrick Westfall knew each other from an army deployment in Afghanistan. Patrick Westfall and Brad Holder practice Asatru. They were members of a small kindred, which is a group of people who believe in Asatru, who gather to hold meetings and worship the gods. They're best friends. Patrick Westfall is a priest or holy man in the Asatru religion and hosted kindreds at his home in Delphi on Sundays. In his home. Did you hear that, DB? In his home, not his house. Pat Westfall. Oh, I already said that. No, he's a Brad Holder attended these meetings. Holder and Westfall attended a pagan ritual, videotaped by Brad Holder in 2016 in Fort Wayne, Indiana, which was entered into evidence. Near the end of the video, Pat Westfall appears to be marking the tree with his hand.
What are you doing, Pat? Oh, no, he did say that he didn't do that, though.
I don't like that. Major Cicero testified that a tree at the crime scene was marked with blood of Liberty German. Dr. Perlmutter testified the mark was in the form of a rune. Major Cicero admitted that whoever sliced Liberty German's throat could have Liberty German's blood on their hands. The forensic pathologist who conducted the autopsy admitted that upon slicing Liberty German's neck, the amount of blood and the force of that blood exiting her neck upon slicing would have been very powerful, squirting as far as 4 to 6 feet, quote, no problem. And that is from the deposition of Dr. Roland Kaur, who again was the pathologist that did the autopsy of the girls. And then the footnote notes that the deposition of Dr. Kaur was not included during the evidentiary presentation and therefore is being provided via first-class mail as an exhibit for the court to consider. Okay. Who died?
What do you mean? Oh, Travis was telling a story of an old friend.
Oh,
So I just gave him a nice rest in peace to Rich.
I'm sorry,
Which,
Travis.
very
Rest in peace.
unfortunate.
That sucks. Rest in peace, Travis. Rich. Okay.
No, not Travis, Rich.
Oh, I know.
Okay.
Sorry. Rich. Rest in peace, Rich. Elvis Fields. I want to go to the end. I bit off more than I could chew. Okay, 25. Travis. I'm sorry, Travis.
I'm sorry, Travis.
I like that Yellow's comment still up. Just leave it forever. Richard Allen has a right to introduce evidence of motive as it is always relevant. Evidence of motive is always relevant in a criminal proceeding or criminal prosecution. In the context of third-party motive evidence, an accused must show some connection between the third party and the crime before the evidence is admissible. In this case, the prosecution has no proof of any connection of Mr. Allen to Abby Williams or Libby German, nor have they identified any motive as to why Mr. Allen would kill them. There is absolutely no evidence as to Mr. Allen's motive to commit the crime. What does exist, however, is motive on the part of Pat Westfall, Brad Holder, and others to kill Abby Williams and Liberty German. Brad Holder knew Abby Williams as his son was dating her at the time of the murders, and he had supervised them on at least 2 dates. Whoa. Pat Westfall participated in animal sacrifices. Asatru sacrifices are carried out in order to provide the offender with power through runes, blood, and binding runes, all of which are present at the location where the bodies were found. This provides motive for Brad Holder and Patrick Westfall to murder Abby Williams and Libby German as part of an Asatru Odinist sacrifice. Wherefore, for the reasons identified above, Richard Allen, by counsel, respectfully requests the court deny the prosecution's motion in limine as it relates to... My shit just went bloody.
No, you're good. I see you.
Okay. Wherefore, for the reasons identified above, Richard Allen, by counsel, respectfully requests the court deny the prosecution's motion in limine as it relates to Odinism, cult, or ritualistic killing. Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Brad Abrams, Kagan Klein, Anthony Klein, or Ron Logan, and for all other just and proper relief in the premises. Signed, respectfully signed, Jennifer Auger, Andrew Baldwin, Bradley Rosie. From the
Pretty
law
serious.
office of Jennifer Auger. And here are all of their table of authorities. Beautiful.
I love how everyone's like, oh, they cited, they did all, all the citation and stuff. And it's like, well, they really had to cite the Sixth Amendment to Judge Gall.
Probably.
They got to cite before. Yeah, I know. But like, it's pretty sad. They're just at the point where they're like, yeah, this is called the Sixth Amendment. This is called the 14th Amendment. This is pertaining to that.
I know. She doesn't really seem to have like a whole lot of, well,
She's got a lot of go.
Her I don't know. I don't know how I feel about her. I just disagree with pretty much everything she's done. So that's how I feel about her. You know?
Yeah, I know.
What do you think about that filing?
I think it's an interesting filing. Well, we're gonna have to wait and see what happens with it. It could be denied. It could be approved. Really,
yeah.
Who knows? A lot of people were saying that they're really pumped up that it has so much case law, but I mean, she's just not gonna care about that, really.
No, she's not gonna care at all. I mean, it's like great to write good motions. There have been a couple that have been good, like great. But I don't think that it's a matter of like, oh, this motion didn't get approved by the judge because it wasn't like it didn't include enough case law. I don't think Nick McClellan even knows that that's a thing that he's supposed to do when he submits a motion or makes a request. Like, it's just he just like doesn't. But she
when you're the state, I mean,
yeah, you don't have to. But she approves all of his stuff, so clearly, it's not because the defense has not supported their claims or their requests with law.
Phoenix says he admits to knowing Brad Holder. Remember all the people that they said didn't even know each other. Yeah, they did say that about a lot of people. I don't know. I think I know a lot of statues that I think are really cool and high authority. What's your favorite statue? I'm gonna troll Luke. Phoenix says it's in the memorandum. Did you meet yourself?
Damn, and I said a really funny joke when you're talking about statues. Never mind. Well, oh well, next time.
Okay.
It was really funny.
Bay. I like this Handsy Bay. This is an all eyes emoji here. Looks like.
Yeah, it's a lot of eyes.
All the eyes.
I don't get it. I don't get it.
Me either.
Fiend, I know it's a memorandum. It's not something she can deny, but it's a memo in support of her denying, like granting their request, which is like, don't fucking grant this stupid motion in limine.
I thought it was a motion in luminescence for the longest time.
Motion in lemonade. Hey, I want to show everybody something.
Yeah, go ahead.
Oh.
That was a little long. But okay.
No, it was perfect.
What do you wanted to do? What?
I'm going to show everybody something.
That's really what you wanted to show them? That's a little weird.
Are you 5, 6, 7? Memo in support of. Get you something to drink, Fiend. Get you something. Don't be thirsty. Why be thirsty when you can be quenched? Okay.
Is this plea deal fuel?
What?
Is this like fuel for a plea deal?
Yes. Oh, this is definitely we are in plea deal territory, I would say. It's
I
like
think
the warm up.
you cite the 6th Amendment, you cite the 14th Amendment, you find all this case law, and then bam, you get that plea.
You surprise them. They never see it coming. That's what it feels like to me.
Let's see if I got any more horns over here, anything I can play while we're. There's one, guys. Let's kill some time here. Oh,
I
here
didn't
comes
date these appropriately. Like I'm
here
supposed
comes old Jerry Holman. Old Twinkle Toes Jerry Holman.
That's a really good sound effect for Jerome, actually. It's kind of perfect. I want to revisit something, if I may.
I'll stop with the noise.
No, please. Please continue. It's great. So, share screen. We're going to share this. Who remembers this? This is Judge Benjamin Diener of the Carroll Circuit Court, formerly of the Carroll Circuit Court. I was going through my Diener archives earlier, and I reread the order that he issued on November 2nd, which is the same day that Tobe Lesenby, the then sheriff, submitted his request to transfer Rick Allen to DOC for safekeeping. The same day, Judge Diener issues this utterly bananas motion. He says, on November 2nd, 2022, Tobe Lesenby, Sheriff of Carroll County, filed a request by the Sheriff of Carroll County to transfer inmate from Carroll County Jail to the custody of the Indiana Department of Correction for safekeeping. The court, being duly advised, finds that the defendant is an inmate awaiting trial and is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. This finding is not predicated on any acts or alleged acts of the defendant since his arrest. Rather, a toxic and harmful insistence on public information about the defendant and this case. So, that has not. So, as we know more about safekeeping now, as a people, as a consumer of this case, the requirements or the prerequisites for somebody to be considered a person in, considered in safekeeping, whatever, custody, it's like very specific. It lays it out right there. In imminent danger of serious bodily harm or death. What does imminent mean, DB? Do you know?
Oh, it's like eminent domain.
Yeah.
Government can come in your house and muster troops on your property.
They can muster your troops on your property? The government? Imminent meaning like, hey, Kokomo, I got so many friends now. I got so many
Kokomo.
friends. Courtney. So imminent meaning like gonna happen. It is bound to happen at any second. Like it is surely about to transpire. No, imminent. Eminent. About to happen. Thank you, Mama Law. Mama Libra scales. So he defines, the requirement for safekeeping: imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. And then he goes on to say, but however, my finding, it's not based on anything that the defendant has actually done or like anything related to him at all. It's just based on the fact that the public's annoying me, asking me to release information about the case. In general, this court has 30 days to rule on any motion that's filed by a party in any case. Yet, concurrent to the actual case naturally occurring, this judicial officer keeps getting direct requests from non-parties for public information, claiming that this officer, when he says this officer, he means like moi, me, the judge.
Oh.
Yeah, I know. This officer has 7 days or 1 day when hand-delivered to respond to the request or face litigation with an exclamation point. Have you ever seen an exclamation point in a filing? I haven't. While this
I was looking for a button that said no. Sorry.
Yes. While this officer is responsible for the entirety of the circuit court docket, it attempts to ignore the maelstrom of interest from the public. It is known that YouTube already hosts content regarding family members of this judicial officer, including photos.
No, it didn't.
No, it doesn't. First of all, I searched high and low, far and wide for a single YouTube, Reddit, Facebook, Instagram, blog post about Judge Diener and or his family and or his children. Doesn't exist. That's a flat out lie. It just doesn't exist. The other part of that, though, is even if it does, Judge Diener is a public figure. He's an elected official. So, yeah, elected officials sometimes turn up on social media, you know?
Benny, what are you doing, hon?
Yeah. Travis, what?
Barbiturate.
Oh my god. Okay. I'm almost done. I'm almost done, folks. Thanks for hanging in there.
Can I say something?
Yes, please.
Hey, everybody out there, ladies. I know you're cooking dinner right now for the family. I know you've had a long day. I just want to thank you for all the support. Sometimes I don't take this too seriously. I make stupid jokes, and I just appreciate everybody, hanging in there with me. And just wanted to say hi and thank you. Go ahead, Angela.
That was really nice, CB. It was great. I think the moms cooking dinner will really appreciate that. It was really sweet. It was really sweet. Yeah, it's not on the list of reasons to put somebody into safekeeping. My family's on YouTube. Okay, Ben. No, they're not. While this officer, me, is responsible. Oh, here you did that. The public's bloodlust for information before it exists is extremely dangerous. All public servants administering this action do not feel safe and are not protected. You're the state. Like, this is a judge. This is a judge. Sir, please.
I wish he would have had half the bloodlust to get that letter that Rick Allen sent requesting his right to be appointed counsel.
Don't you? Yeah, don't you? Me too. And I was thinking more about that, DB. Somebody hand-delivered that letter to the Carroll Circuit Court, the clerk's desk. And that was a great thing that they did. And I don't know who or why or what their motives or intentions were, but they certainly were not required to do that. Right? Like, a letter gets returned because the sender's no longer there. That letter tends to go in the trash. I would feel like that'd be a totally reasonable thing for somebody who doesn't care. You know what I mean?
Or they stamp it and say that they're no longer here and then send it back to the post office, but it didn't get postmarked again.
Right.
It was still
they didn't
postmarked to be canceled.
Yep. So it stopped its trajectory as far as the post service goes. It stopped when it got back to White County, and it was stamped that the inmate was no longer there. But instead of sending it back to the wherever, Indianapolis or wherever it would go, somebody got it to the court, which is where it was addressed to go to. And I just wonder, thank goodness. I mean, not that I'm not going to say it didn't make a difference, but at least he got to be heard, his desperation. I mean, we're talking about it now. So I was thinking about that, but I digress. The Carroll County Sheriff has limited resources to conduct its base operations, let alone any duties mandated by our Supreme Court. Here we go. All defendants in all actions are presumed innocent. All public information will be available the second it exists. Is that will it? So it doesn't exist?
You can't be promising things that you can't be doing, and you know you wouldn't do it anyway.
It's so weird. This is such a weird order. And then he goes on to say, all defendants in all actions are presumed. All defendants in all actions are presumed innocent. All public information will be available the second it exists. None of the family members of public servants are part of this action. Okay. All of the public servants are simply people doing their jobs. Okay. Most of the public servants are woefully underpaid. Most of the public interest consists of people attempting to raise their status or profit financially. So
this is a Wendy's.
Sir, this is sir, this is a Wendy's. What are you going on about? I don't know what any of this has to do with a safekeeping request or the requirements for a judge to grant a safekeeping request. None of that is relevant. When the public peddles misinformation with reckless abandon, we are all not safe.
Do you feel like he was talking to you directly?
Yes. I took that.
He said they posted pictures of my family. I went, unraveling YouTube. I don't see any videos or pictures, so I mean, doesn't seem like anything.
To be fair, we hadn't done that yet. So
oh, okay, my bad.
Yeah, timeline is important. But
yeah, the timelines can be shuffled around these days.
Oh, sure it can. Yeah. We know this. We know this intimately. As for the public's desire to learn about access to court records, that educational effort cannot be by this officer educating each individual ad hoc. Wherever they choose to seek public information, these inquiries are inherently disruptive to the operation of the court, as they're wholly outside the operation of the court. You know what would help the burden of getting so many individual requests for public information? You know what might help?
Well, it's going to be released the second it exists.
Yeah, right.
Maybe you could just wait a few days.
He's like, guys,
you don't need it that second.
Guys, they're almost done authoring the PCA that I signed. Like, they're almost done.
And we're about to send this man to prison.
Yeah,
for 2 years.
Yeah, we're about to sentence this man. Tony Liggett is almost done authoring up his bold italic probable cause affidavit to arrest this guy who's already in DOC. Jesus.
Probable cause affidavit coming through. We have a suspicious man acting suspicious.
Travis.
Activity.
Did you say suspicious man acting suspicious? Yeah, they'll do.
That was the cops.
The cops, yeah, they're back. Travis, I'm gonna do another Diener live since the last one that I did is no longer with us, and we're gonna talk about this because Diener has gotten himself spanked in appellate court a couple times, and it's kind of like satisfying and hilarious, but his recusal or his resignation is of great interest to me personally, just out of curiosity. And the more I see about, well, actually, hold that thought. So
we touch on this real quick because Travis mentioned
yes.
it. I'll be really serious for 30 seconds.
Sure.
29. We're almost there.
Okay.
I think footnote is correct on these. Talk about Osbrook. The court should have appointed him counsel before he issued this order. And I think we all agree that that's, what we would want in that situation if we were in the situation. However, the argument is probably going to be that he was seeking counsel. He was seeking his own private counsel, but because of his situation being in a jail and not knowing how to send legal mail out of the jail, we believe that he did pen a letter to the Carroll County Court that asked to be appointed counsel and to stop his request for time to hire private counsel, thus giving up his right temporarily to being appointed counsel.
Yeah.
That it actually happened. He requested it 10 days before they even knew about it. And I do wonder how that would have changed things if they had the letter in hand for that hearing.
Yeah, well, right, because then he would, first of all, they would have had a hearing, a physical safekeeping hearing, which there's no indication that he was ever even afforded a hearing with or without counsel. I mean, have you seen?
Zero. I mean,
I haven't.
and he was in White County Jail,
He was in White County Jail.
and then they transported him all the way to Carroll County. I mean, it's not that far; it's one county over. But like,
Right. No, they're not going to do that.
there's no transport order, right?
Certainly not.
They're just swiping dudes up.
Yeah. Yeah, dude. It's fucking scary. This shit's scary. I don't know. Like, that's fucked up. Can't even get a hearing. It's not like a suggestion, right? And we saw earlier today that in the safekeeping, the fucking Indiana Code of the safekeeping chapter of the Indiana Code, the very last like little sub note is that a defendant has a right to refuse a transfer if the only, issue at hand is safety, like physical threats of like physical harm or injury to like, and that's the only thing they cited. So Rick technically could have refused his transfer to DOC had he even known that. I mean, technically, not that they would have, nope, but certainly nobody told him that. He didn't even have a hearing. He probably didn't even know where he was going. They probably just put him in a van and drove him to the Indiana Department of Correction, 2 hours away. That's crazy. If defendant is unable, here he goes. He says, as a branch of the Supreme Court, any request for public information about this action should be directed to whomever is the public information coordinator for the courts in general. If there's no such position, our state may need one. So he's like, if any of you have a problem with what I'm doing here, tell the person whose job it is to worry about it. And
which
if
he
that
called
person,
himself that person.
I know. He's like, and if that person didn't exist, maybe he should. I don't know. Just a thought. But it ain't my problem.
Isn't this like right after he got yelled at by that one guy on YouTube?
Yes, by the disabled man.
Yeah, he yelled at a disabled man that was like, "Hey, I was just seeing if I can maybe get some help over here."
He's like, I'm just trying to get information about my case. He's like getting 80. It's something with ADA related. And didn't Carroll County have a fucking busted elevator for a year and a half so that they had to literally like have meetings and hearings in other places in the county because they didn't fix their elevator, and people who couldn't get upstairs otherwise like couldn't fucking go to their meetings? It's crazy. Anyway, yes, this was very soon after he seemed he was kind of hot at the time. He was kind of a loose cannon, and it doesn't seem like he got any less hot as time went on. So defendant indicated at his initial hearing an intention to hire private counsel.
Defendant in a double life without parole case, potentially at that point, no clue whether or not they're going to seek the death penalty or not. And he told Judge Diener, I think I want to seek private counsel.
Wouldn't you?
Who has an hourly job at CVS. And he's talking about, oh, okay, yeah, go ahead. Didn't check back in with the guy after he'd made a few phone calls. Didn't think about maybe giving him a line of communication to him in case he wanted to be appointed counsel.
Clearly not. I bet, like, why is he writing a letter when he can pick up a phone? Maybe he couldn't pick up a phone.
Yeah, well, we know Diener's record on the phone around that time was not great.
His phone manners are not great. He does not have great bedside manner. Oh my God. Defendant is reminded. This kills me too, by the way. He's like, defendant is reminded that he must retain counsel within 20 days of the initial hearing because there's deadlines. He's reminded how? By this motion? Yeah, he'll just pull up his
deadlines. What's the worst that's going to happen? You're going to get chucked into ADSEG in one of the worst prisons in the country?
Yeah.
No, wait.
The pit of hell.
That already happened.
Right. Yeah. Be careful. Don't miss a deadline or else what? The worst thing that could literally ever happen to a person has already happened. So It's just it's crazy. There are deadlines for filing motions, and if these deadlines are missed, the legal issues and the defenses that could have been raised will be waived or given up. Did he waive or give up his right to a hearing before his transfer? Like you're so concerned about him not missing deadlines so that he doesn't waive his rights, his due process rights.
I mean, there's another case where there was a young man accused of a horrible crime as well, and was later found guilty of it. But the way Diener talked to that guy from the bench was kind of disgraceful too. Like
Yeah.
a defendant in open court admonishing them about like not knowing something that a layperson, 19-year-old layperson probably wouldn't know about the law.
Right.
And he was just total jerk.
He's dragging him. Like he berates people. It's like a berating. It's ugly. Yeah. If defendant is unable to retain counsel of his choosing due to financial indigency, defendant is reminded that he's entitled to court-appointed counsel, and defendant will be examined upon request.
What if he didn't know?
What if he made the request and it got sent to fucking no man's land? Or what if he
Well,
made the request?
This wasn't read orally in the court.
I
This is an
know.
order after. How could
Right.
he even? He doesn't have an attorney.
Who's going to tell him?
Initial hearing was on a Friday.
Right.
That's nice.
Of course. And then he gets moved. Yeah, it's awesome.
And he wanted to
And
go
then
home.
He gets moved to White County on probably a Saturday. Like, what a mess. And I just keep feeling like he's like, no, I don't want a public defender. Like, charging me with murder. I didn't murder anybody. Like he probably could not have possibly in a million years imagined that this would get this far. Like, surely they'll realize the error that they've made, and they'll realize this is just a huge misunderstanding. And surely I'll be home before I know it. Like that.
He's probably like still reenacting in his head how pissed off he made Jerry Holman. He's like, man, that guy got fucking worked up over nothing. Like, soon the Riddler's gonna find out about this, and it's all gonna get cleared up. There's no way they really think he did.
The Riddler will help us. Yeah, Rick had no idea. He really didn't. Because who gets charged with something like, yeah, you just can't imagine this actually like happening and playing out in real life. The court notes for the public that when the defendant appeared for the initial hearing, he was clad in protective gear. That protection was not to protect him from the court. It was to protect him from the public. Like, why would he need protection from the court? Why would he need protection from the UD? Like, what do you mean? Nobody here is assuming.
Protection was not. See, okay, I just realized that it said that because in my head when I read it, like every other time I read it, it didn't click to me that he actually said that because it's so fucking goofy.
It's so fucking
protection
goofy.
was not to protect the defendant from the court.
Yeah. Well, like no shit, Ben. Nobody was thinking that.
If he had any protection from the court, it would have been an appointed fucking counsel.
Thank you. A fucking attorney?
You couldn't have a public defender, not even a death certified one, not even an LWOP certified one. You couldn't have old fucking Monahan walk over from the public or from the fucking sitting in the lobby at the prosecutor's office to do a good old solid for you.
And you know that most judges would be so horrified at the thought. Like most judges, even like mediocre judges, would be so horrified at the thought of a defendant who has no idea what's going on, guilty or not, like being unrepresented before you in a courtroom. Like, and you're about to make decisions about this defendant and their case as a judge with total authority, and this person is totally unprotected and unrepresented. That would be a horrifying kind of scary thing. And so wouldn't most judges be like, how about we appoint you a public defender while you look for private counsel? Like they would make that recommendation very, very strongly and would explain to the defendant why that is a really, really fucking critical thing for them to have that protection.
Well, a lot of judges are accountable to the people that they represent in their county. They're accountable to the superior court judge. They're accountable to anybody. And this is a person who's clearly not faced any accountability for the things that they've done outside of a you know, very scathing court of appeals opinion that was just recent. But like, he's acted with impunity in a lot of these cases for so long that
Yeah, he has.
it's like, why would he think? And then he's just gonna chuck him into fucking Mount Doom because he's gonna recuse himself. Make one of the most. He confessed 61 times allegedly in DOC, right? He's in DOC because of a judge who
Diener,
recused himself
the day
instantly.
instantly. Yeah. Yeah, and then I think about like the implications of like Fran is now Judge Goal is now in charge of making the decisions about about Judge Diener's behavior and thinking and what Judge Diener would have thought had this like Judge Diener would have found that there was probable cause if all of this other shit was omitted. There's still we can't ask him because he's not fucking here. So we really don't know what happened, except I want to read another document, but I need to take my dog out. So you can hang out and entertain the masses if you want or not, but I'll be back and I'm going to go.
I'm going to count to 150.
Okay. Well, I'm going to try and be back before you're done. I'm not going to, but I'll try, but I'll be back. Do what you want. Don't help.
All right. Here we go. Everyone knows how to do this, right? We're going to start here in just a couple seconds. Got to get ready for this. I'm going to pull up my number chart here just to make it a little bit easier. Let's see. Actually, you know what? I'm not going to use the number chart. I'm going to do the calculator. I'm going to click 1 + 1 and then enter. Okay. 1 + 1 now equals again. That's 2. Equals again. That's 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29. Are you kidding me? Drop Phoenix a link? Can he count? Mr. X. Show me some counting skills in the chat and I'll see if I can get it. Your eyes are in spirals. Have you never heard somebody count that high before? Be impressed. Let me just log onto my X here. Not that X. Oops. Hey, everyone put a 1 in the chat if you want to fiend in here real quick. Criminal Network, where you at, dude? Are you out there with Roto, dude? We need to get you up here sometime. CN. I was a big fan of the Cartoon Network, and then once I got older, I became a big fan of Criminal Network. The one is for... No, I was talking about StreamYard, not California, dude. But I think they got StreamYard out in California. Is this guy going to come up here? Just put 1. Aaron says, Elon is a strange man. Changing the name of a huge company just to have an excuse to always talk about his ex.
Oh my god.
Oh my god.
That was so fast, wasn't it?
Yep, I counted all the way up and all the way back down.
Okay, good. Perfect. Okay. What
I did send the link out to some unsavory folks.
Okay.
Just so you know.
My OnlyFans? Different
No
link.
one ever calls it X.
This link, you mean?
Yeah, not only. No, not that one.
Okay. I ran so fast.
Iraq.
Okay. Get it.
Hi, everybody. This is Phoenix.
Oh my god. Hi, Fiend.
What's
You
up?
guys,
I'm actually DB.
Hey, DV. I'm so
You guys
happy
actually
to
thought
see
I was
you.
gonna fucking let Fiend on here? Get the fuck out of here, dude.
You're not really
Get
Fiend?
the fuck out of here.
I'm a sucker.
I'm
I
just
should have
kidding.
known. Is it really?
It's been real. This is Fiend, everybody. He's a good cat. And everybody welcome Fiend.
Hey, Fiend.
What's up?
What you been doing, man? What's new?
I'm on a wilderness retreat.
Wait.
That sounds
Really?
very paganistic.
Yeah. Listen.
I literally hear the sounds of the outdoors.
Yeah.
It's beautiful. I like that.
I wanna can we do that again, Fiend? Put it up. Fiend. What are you doing? All right, go ahead. I'm gonna take myself off. You two.
Yeah,
gonna
take.
crash.
Why don't you go take yourself off, BB?
I'm gonna take a lap, guys.
Take a lap and talk to you soon. Thank you. Fiend, a wilderness retreat, huh? How is it going? What's your favorite thing about your wilderness retreat so far?
It's classified.
Okay. Oh, good. This will be a good talk then. Okay.
Top secret mission.
Okay. Cool. Well, then don't tell me. I don't want to know. How do you feel about this here motion we got today? You had some good stuff to say about it.
Yeah. No, I think it's pretty strong. I think I think OJ is she's
And
on
OG?
it.
OJ is the OG.
Yeah, she's on it. I think she makes a really compelling case for both legally that this has to this should be admissible type of stuff, and a good reason to deny the motion in limine, but also I think it builds on the defense theory, and I think that if you had any questions about whether the defense is really like backing this theory, I think that this is a good indicator that that this is. I mean, and they've added some additional details, a lot of things that, people said, well, but, that's not true. That's not true. Where's any proof of that? Well, they add some additional
the autopsy
stuff.
report, like mentioning the fact that they deposed Dr. Kaur, I guess his name is, who did the autopsy report.
Yeah.
And that in that report, I like that all they said that they kept it simple, like a knife, like.
Right. Yeah. No. They get the knife. I think was big. I think that there's the one of the things of drawing a nexus between some of these individuals has been questionable, but they've got the deposition of Elvis Fields, and Elvis Fields admits to knowing Brad Holder. Well, okay, that's by his own admission. That's not you don't say they don't know each other. I get that they're all saying different things, but that inconsistency is actually a point of their case. I mean, if they're not going to investigate it, then put it in front of a jury, and see what a jury thinks about this. I mean, it's kind of silly to not include, the main. I mean, I always thought the main pillar of this defense case is going to be missteps in the investigation, and
I think so. I think it should be,
and not missteps or mistakes or just doing things improperly or not thoroughly or diligently. And I mean, you can't just cut out like half of the investigation. Like this is the investigation into the crime. Like, why wouldn't you bring up this stuff? Law enforcement actually looked at all this stuff, so why not bring it up and talk about it?
Well, yeah, we know why, probably because it's a really good defense and it's really legitimate.
I mean, honestly, I think that like the motion to eliminate was like overly broad, and like I my initial reaction to it seemed like I don't think they're gonna get all that. Like they're just asking for the world. So I don't know how she's gonna rule on this thing. That wouldn't be surprised if some stuff doesn't come in, but I feel like some stuff definitely does have to come in.
I almost feel like she gave them these hearings they requested so that she could turn around and deny the Franks hearing and not be so scrutinized for it. Like,
yeah, a little bit. Maybe I'm not sure.
I just feel like I was surprised that she scheduled anything at all, obviously, but I mean, she really did hear a lot of evidence those 3 days, and she gave the defense way more latitude than we've seen from her. Obviously, a fair judge would be doing that the whole time, but then to turn around and deny again the fourth request for Frank's hearing.
Yeah, I mean, the Franks is. I mean, there's just it's all a high bar. I mean, I would really prefer that they had a hearing on it. To just vet it and get more in, but like here they are getting more stuff in, one way or another.
I agree.
And the thing is, I mean, I find it interesting that the defense continues to provide more and more meat. Like they're adding to their theory. They did it in hearings. They're doing it in this filing. They're building a case. They're like, and it becomes more and more compelling the more details that they add. Juxtaposed against the state, which I don't have any clue what their theory is. The defense kind of says what their theory is, but I think that they're even. I think OJ stretches it a little bit because I don't know that that's the state's theory. Because they haven't plainly stated anything. They don't say the murder weapon's a box cutter. They said, "What if I told you it was a box cutter?"
Well, what if he admitted to it being a box cutter?
Fuck you. Why don't you say something? Say something definitively.
Is a box cutter a knife?
I mean, kind of. I mean, it's a blade.
In an autopsy report, it's not. In an autopsy report, a knife is a knife and a box cutter is a box cutter.
I don't know. I'd almost say that it's like a razor rather than, I don't know. I'm not sure that I would say it. I don't know if I would call it a knife.
You'd call it a.
I mean, you would call it a utility knife. I mean, it could be. I don't know. It's a little bit of a gray area.
It's a slicing instrument. And if the autopsy report says that they were stabbed with a knife.
Hey, Travis, are you putting, if you're a prosecutor or if you're a defense attorney and it says that they were looking for a knife and they took a box cutter out of somebody's garage, and they didn't specify that they wanted a utility knife or a box cutter, is that a specificity issue?
I mean, I think it's weird that they didn't. We know what they took from Richard Allen's house, and they took a bunch of knives. What they didn't take was tools or a utility knife or a box cutter. Like they didn't raid his toolbox. That's not included in their list of things that they took that they were even looking for. Yeah, and they didn't say that they were looking for that sort of thing. Like they didn't add tools and like to the list of things that they might be looking for.
Right.
So I don't like this idea that it's a box cutter. It seems to be, a post hoc sort of like thing, if it's really a thing at all. Which I kind of doubt whether it is.
Well, would they have spent what we now know was over $1 million, over $1 million taxpayer dollars, searching the Wabash River for a knife that Kagan had said was the murder weapon that he threw into the Wabash for the clam jam, would they have spent $1 million looking for a knife if the murder weapon was a box cutter? I don't think so. I would hope.
Well, I mean, I also just take it like a little bit like, hey, if there's so much credence to validate a $1 million search, where's the $1 million search? Like investigation into Rick Allen? Like where's that? Like they're not even doing that. Wouldn't they? Wouldn't they like do $1 million search? Like let's dig up everything on Rick Allen. No, they don't do that at all.
Yeah.
I mean, the box cutter, like, they were like, oh, well, 6 years later, we went by the dumpster. Obviously not there, but, like, I looked at the dumpster. Like, there is a dumpster there. Okay. Well, like, what's that supposed to do?
Are they saying that after Rick makes this alleged incriminating statement about a box cutter, they then went...
Holman went and looked at the dumpster. I don't know that he actually searched it because that would be kind of stupid, but
didn't he say we searched the dumpster?
I don't know if they.
So there was a dumpster there.
Yeah, and of course there's a dumpster there. Why wouldn't there be a dumpster there? There's a dumpster.
There were places to throw stuff away.
I don't know. I'm not following what they're putting down because they're not putting down anything. The state is not like saying they didn't even say it was a box cutter. Like they definitely didn't.
They didn't. Yeah, he asked Perlmutter.
What if I told you?
She talked about the autopsy. I don't know what they asked her specifically, but what I hear is Perlmutter was asked, could it have been a box cutter?
Would you change your mind if I told you it was a box cutter? And she's
there
like,
you go.
No. Like I don't know. Like I do think that, like, I don't know. I think there's probably like some credibility that where she could be like questioned, but the things that she's being attacked for, like, that's probably not the route to really question her credibility. Like to say she has an art degree or something. I mean, she's like, I don't know, like if she's training law enforcement, she's training feds and law enforcement agents, like on this stuff. Like, what do you have? Like, well, do you have a problem with those law enforcement like entities, like allowing her to train them? Because,
or how about the fact that you think that a first of all, Cicero is not even a blood spatter expert. He's a crime scene investigator who had training in blood spatter analysis, which is not a scientifically sound, accepted scientific forensic method. It's one of those pseudosciences, which has merit, but certainly not definitively as we often see it be referred to. But so what the fuck's their problem with women is my question. And I'm not trying to get into it, but like, they don't have any female investigators. They fucking didn't even... We've never heard about... The only reason we know about Nicole Robertson, who is an FBI agent on the case, is because her affidavit got leaked. And you have a woman on the stand, whether or not you think her field of expertise is stupid, which certainly they do, like, to deny the fact that a woman who... Doesn't she have a PhD, Fiend?
Yeah.
She has
she's Dr. Perlmutter.
She is a doctor. Yes. So she has so much education and experience and knowledge, so much so that the federal government and local government are trusting this woman, this expert, to train their officers. Like, on what?
Yeah, I know that. I mean, this is what people are like, oh, there's no such thing as these ritual killings. Like, well, the government thinks there is.
Sure. Maybe
because they're hiring somebody to train their people about these sorts of crimes. Like,
yeah,
so get the fuck out of here with that. Like, that's silly. Yeah. It's silly to like be like, oh no, it never exists. Like, but then I'm like, except for this one time. Well, it's not just that one time; it's a bunch of times. Like, you
think that jurisdictions and federal agencies and law enforcement want the general public knowing that there's a bunch of white supremacist occult gangs and cults killing people? Like, you think that we hear about every single time there's a weird murder, or every single time a murder has like symbols or signatures or aspects of it that are like spooky and weird and creepy and occulty and Odin. Like,
well, I mean, I think it is like relatively it's a rare occasion.
Of course, it's rare.
That's why you have like a very niche like expert of like, I don't know how many people really are experts on that sort of thing. Probably not very many.
No. Right. Yeah. It's very interesting. And then I think about, our friend, I don't know if you go on Reddit. I don't anymore, but at one time I did. There's a lawyer that posts in the Delphi docs a lot. And this person from the very beginning has been justifiably ranting about how there's many reasons that they refuse to investigate or avoided investigating or whatever certain avenues. And one of them could be the fact that a crime that was committed by or in the name of or whatever, like a hate crime, a hate group or an extremist group or a gang or whatever, like that might get some federal attention. And
well, I mean, the thing is, it did get federal attention. You've got joint task force, like terrorism task force, FBI agents, the multiple that are investigating this thing.
Right.
Like, we know Ferenczi and Murphy, like that they had positions with the FBI in the terrorism task force.
Right.
Like, so we know that they think that there's some indication of that, and we know that that they looked at this early, like having like some tie to this. And I mean, that the defense is rightfully like continuing along that line of investigation. Why wouldn't they? They're required to investigate.
Yeah. Have you seen any animals?
I saw a fox the other night, and saw some turtles eating a dead fish.
Nice. Turtles are pretty cool.
Turtles and foxes are only present in the Pacific Northwest, approximately 30 miles below the border, and dead fish as well. So I think I triangulated him.
We're on the way. I had my people
almost got my coordinates.
I had my people look into it. I'll be there soon. So foxes, turtles. I saw a fox the other day actually, and I saw it during the day. And I always thought that if you see a fox during the day, that means that it's like sick. But it didn't look sick. It just looked like he was just
minding his own business.
Yeah, he was just awake. I was like, you're supposed to be asleep, but I don't know if that's true. Is it?
No, I've seen a whole family of foxes out, like by my place, probably about a year or two ago, and they were all frolicking out in the day.
Okay, there you go. That makes me feel a little better. Yeah, I was worried about it.
No,
I like
they look plenty healthy.
I can't watch nature documentaries of any kind because I get tremendously anxious about like
whether somebody's going to get eaten.
I have been told by multiple people, I personify, like I assign human emotions and feelings and thoughts to like animals.
You anthropomorphize.
Yes, Yeah. Say it again.
I can't say it. Anthropomorphize, I think.
Sure. Okay. That sounds like what I do. And so like, let's say, I don't know. Like, oh my God, Boone is like depressed because blah, blah, blah. And like, I took him to a dog trainer not too long ago because he's bad. He's a bad dog. And I took him to the trainer and the trainer was like, can I say something? And I was like, yes, lay it on me. And he was like, so obviously you love this dog a lot. He's like, your love for the dog is making your dog a fucking anxious, neurotic. Like you can't treat your dog like person. And I was like, But he brought that up. He's like, dogs, like, they're hungry, they're thirsty, they're tired, they have to go to the bathroom, they're bored, but like they're not sitting around thinking like, God, like Angela stepped on my foot yesterday and like didn't even say sorry. Like they're not like thinking about shit like that. But if I'm watching a nature documentary and there's an animal that, for example, prefers a life of solitude, a lot of like, there was like some kind of like big cat, like a bobcat or something. Like they live totally by themselves. The only time they're around other bobcats, I'm saying bobcat is a different kind of cat, is to like mate. And that's it. And they just want to be alone. And I'm sitting there thinking like, it's just like this lone cat walking through, and then they like pan out and it's just like this cat walking in the wilderness. And it's just like, it just like upset me. I don't see the appeal.
That's not a bad exception to have. I mean, I get it.
Yeah.
You want to be alone, unless.
Yeah, but like, who cares? They're obviously, if they didn't want to be alone, they'd be pack animals. They're fine. Like they're not worried about it. But yeah, it stresses me out. Or like if I'm rooting for an animal and then they don't get away, I'm like, God, you think that animal knew that their life was about to end? Like, were they thinking about like the last time they saw like their, Anyway, it's a thing. I guess people do it. All of that to say, I'm glad that you saw some tortoises and some foxes. Mandy says, "Am I a fucking bobcat?"
I didn't make up electric werecats. I found a Reddit post that mentioned an electric werecat, and then I just latched onto that idea.
Yeah, but then you read us that. Wait, didn't can you say again why you Judge Cole?
Oh, because so like the idea behind the electric werecats is that they would cause problems with like the transformers and like up in that area. It's in that area too. So like she had this real strong aversion to electronics, and you can't bring your phone in, and like I thought that maybe like that would give her away. You bring your phone in and it just starts sparking. But I went to the hearing and a bunch of people had laptops in there. I was like, you know what? I think that theory's debunked.
Debunked. God, that's funny. Okay, yeah, the werecats can't be around electronic devices of any kind, right?
I mean, I don't know. Like, there's more research needed.
You don't know.
I'm the preeminent electric werecat like expert, but there's not really that much to know. So I just shrug my shoulders and be like, I don't know. Nobody knows.
Yeah.
But it doesn't mean that we don't speak the truth that there may or may not be electric werecats.
It may or may not be.
Right. Yeah.
I don't see any evidence.
Search continues.
I've not seen any evidence to suggest that there's not.
Exactly.
So yeah.
There's also just like the whole like philosophical, metaphorical like interpretation of it. Like the electric werecat was inside me all along.
Can you put this comment? Hold on. It's so upsetting. Hold on. Oh my God.
No.
Oh no. It's so sad.
Don't run over squirrels, and then
why would you tell me that? Oh no, they're generationally territorial. His whole family saw you. Oh God.
And they're coming for vengeance.
They're coming for revenge. They will have.
They're never gonna forget.
They will have their. Vengeance is coming. They will have their justice. Oh my God.
I'm imagining all these squirrels with their like V for Vendetta masks.
It's so stupid. Oh God. Yeah, I love you too. A lot. Squirrels will eat from your hands. I know. They're really nice. Actually, that's not true. The squirrels on my college campus were like an actual problem. They had to like bring in specialists because they were like.
Dude, I have a distinct memory from like probably like middle school age, I'd go to Purdue for a science camp. You do science classes and then stay in the dorms and stuff there. But the squirrels there are fucking huge. Indiana squirrels are big. I've gone to a bunch of other states and they're not nearly they're the squirrels in Kentucky look like rats. They don't even have any fur on their tails. They're mangy. And they're all tiny. But the squirrels in Indiana are fucking hogs, man.
They're built different.
They're real squirrels. So I don't know what
they're built different out in Indiana.
Right, they're corn. It probably they've got all this access to these crops of corn and stuff, and they're just getting fat as fuck.
Oh God! Are you building fires and roasting marshmallows and
no? I'm glamping.
Oh, okay. That's preferred. That's preferred. I've only been hardcore camping once. And I wasn't great. It was not great.
No, I've done real camping before. I'm just getting I don't know. I don't know if I would do hardcore camping by myself. That kind of just seems like a lot of work. If you can you need some division of labor for
true.
All that
it's
work.
True. Yeah,
but
there's a lot of work.
I mean, I'm an Eagle Scout. I did a bunch of camping.
Really? Not to brag, but Fiend is an Eagle Scout, ladies and gentlemen. Right. That's pretty cool. That's nothing to that's a big deal. Eagle Scouts. That's pretty cool. So you know how to build fire and you know how to what else do you have to know how to do as an Eagle Scout?
Man, I don't know. It's so long.
I don't know. I don't know.
Dude, I'm so old. I don't remember things. I don't remember things from that long ago. I mean, I got a bunch of merit badges. I remember that. So, at one point, I must have known how to do those things, but
oh my God,
I don't know how to do any of them now.
This is true. It's been a long week. It's been a long week.
It has been a long week.
Right?
There's been some action.
Mandy would like to know, Fiend, do you still have your uniform?
Yes, I probably do. I can guarantee I would not fit into my uniform.
That's okay. That's probably a good thing. Well, any more thoughts about anything?
Any more thoughts? No, I guess maybe I don't know if we'll expect to see I don't know. You can kind of get this tit for tat going. So I wonder if Nick McClelland would like to file a response to this memorandum. Because I think it's pretty compelling that I think you read through this memorandum and I mean maybe you just agree and say, hey, it makes a lot of sense. Deny the motion to eliminate. I think that maybe it might be smart for the prosecution to file a response and say, no, don't deny the motion to eliminate. We really want. Really do not want these things talked about at trial.
Please.
I don't know. I think it's telling where there's this where there's a push to on either side of what they want in.
You can definitely tell. You can definitely tell what they prioritize and what.
And I'm surprised. I thought the defense would kind of kind of negotiate on some of these things and be like, hey, we don't need this and we don't need this and all. They want all these third party people in. They didn't forget Keegan Klein and Tony Klein or Ron Logan.
No, because I think
they're making their cases for those guys too. And I mean, I think that reading through that memorandum, you can almost imagine a scenario where I don't know, I mean, just because they didn't find the knife in a river, finding a knife in a river is a hard thing to do. Like, should you totally discount that's not completely true because it doesn't not fit in with kind of some other stuff.
And now on that topic, let's talk about the Dropbox. No, I'm just kidding. Please, I don't want to talk about Dropbox. No, I agree with you, Fiend. Like, how confident are we in anything that the investigation has said or done? Like, okay, they tell us that there's no client connection, which, like, personally, I don't think there is. But like, why would we believe anything?
Well, anything? I mean, I think the part that they put in there is like, the Keegan Klein goes with Tony Klein, and Tony Klein comes back with blood on him. So like, Keegan Klein's not involved, but kind of involved, but like he's not involved. I don't know. Like, I have no idea. Like, whether Tony Klein is connected to any of these other people, but like, I think you can assert, like, I don't know. Like, I know a jury, like, hearing all this might, make a connection, even if they don't show much to it.
I think the reason, like, I agree, they could definitely argue that they're all, like, all of the third parties are relevant, and they could, because it could have been any of them. But what I think they're doing, and what I'm actually, like, really glad to see them doing this, is they're not making concessions when it comes to issues that are black and white legally. Like, there's been so many blatant, like, very, very clear, like, a lot of things are obviously ambiguous in law, but there's been so many things that are just black and white, just wrong, that the judge has, like, ordered or denied or ruled on or done or allowed, or that the prosecution has done. Like, there's been so many instances where the defense is probably just sitting back like, what the fuck is going on? Like, they probably cannot believe what they're up against, in this case. And I said this about the confessions, and I feel this way too about the third-party evidence. Hi, DB. If you're going to admit the confessions that were obtained as a result of a constitutionally violating decision by a crazy judge, then it just, like, none of those confessions should get in the door. They shouldn't be, like, splitting hairs over which one is legitimate. Oh, was he lucid or stable and sane when he made this one? Like, no, there's no confessions. Yeah.
Oh, I just wanted to let everyone know we got this new merch drop. We're dropping this immediately. 100% of the proceeds go to a channel moderator associated with this channel.
A channel handler. Is that seagull eating a fish?
That's an expensive shirt.
It's an alright price shirt.
It's $86 for the low price of $86.
Well, I gotta, it's not been the most lucrative. I mean, the channel moderator has not made the most money.
Neither has the channel. It's hard. It's
okay.
Hard
can I finish the plug? I mean,
no. Go ahead, finish.
$86.
I'm gonna mute myself. Is that it?
That's it. Thank you, everybody.
That's all you're gonna say?
That's it for me. That's all I wanted to share, and hopefully people are interested.
I'm interested. I think it's.
Yeah. I've seen worse. I've seen more expensive shirts, and it's like it's going towards a good cause. It's going towards a really good cause, which is bankrolling DB's groovy lifestyle as channel mod. I can't think of anything I'd rather do than give $87 to DB.
86.
To buy a new keyboard.
It's $86.92, not $87.
$86 to purchase a brand new keyboard that he will then tinker with.
A pricing strategy where you just knock it a few cents lower. So like it seems way cheaper because it's not $87. It's $86.92.
Yeah. It's just $86. It's like an electronic that's $499. It's like, well, it's like $400, not $500 because it's like $499. It's girl math. But I think that anyway, my point is, I don't think that they should be selecting individual concessions when it comes to like big issues such as like, does the defendant have a constitutional right to put on and present a defense, or does he not? And if the answer is that he does, then all of their relevant third-party defense should be admissible. It's not to say they're going to like put on like a 6-month trial and present every theory, like obviously, but I just feel like they've yielded and conceded so many times thus far out of necessity and out of critical, concern for Rick. I feel like now we're maybe at the point where like they should be making these larger, broader constitutional arguments, like fruit of the poisonous tree equals all of the confessions that were obtained through coercion and unlawful detention and constitutional violations.
I mean, there's also just, I get you gotta kind of like legally analyze each individual part of this, but like there's also like judge kind of like is an arbiter and like maintaining fairness in this, and the state's getting in some bullshit. Like they've got in this cartridge. They're gonna get in like experts that say like this junk science like tool mark matching is like has any validity to it at all, and they're gonna get like you're gonna get statements that are made under duress. Those are probably coming in. Like, when you're allowing all that bullshit, fucking let the defense bring in their shit too.
Right.
But I think that they did make a pretty good legal argument that they should be able to bring it in.
I agree. Yeah. Show the jury everything if you're going to show them anything. The cherry picking is concerning, right? So apparently what's happening is like there's 61, I don't know if they said 61 incriminating, and it's just like, it's just so performative to even say that number. You know what I mean? It's just such a Nick McClellan fucking move for him to be like, there's 61. Like, shut the fuck up,
Yeah, we have no idea what qualifies. Like,
he doesn't have to prove that. That's the thing. He loves to get in front of the public and get in front of the judge and fucking dance and talk about all of this shit that sounds really, really good, and the news just laps it up without asking any questions. And there's no requirement that he prove or back up any of it. He can just say there's 61 incriminating statements, because like, who's gonna because prove there's not. Like, obviously we can't. But for him to be like, okay, well, this one can come in and this one can come in and this one can come in, but the confession he made about killing Kathy and Janice that he made to Kathy on the phone, that one can't come in. Like, why? No, they all come in. That's also a confession. It's not legitimate, but neither were the other ones, because he was in fucking psychosis. He was fucking psychotic. So the cherry picking is a problem, and I don't see how. But I cannot see her excluding all of them, even though I think she should. She won't.
I'm not really sure what she's going to do. I don't know. I think she's hard to read. I think there's definitely like a lot of people just wanted to say she's just going to deny, but like I think that like it's typical in a lot of these cases where the state wins a lot more than the defense wins, but the defense wins some things, and I think that tracks a little bit for this case as well.
I'm trying to think what the defense has won that's been like actually like meaningful and impactful and helpful to them.
Not a whole lot. The safekeeping order finally getting vacated. It is too little, too late, but it eventually there is the caveat that the public has zero fucking clue where Richard Allen is right now, and the state is completely hiding that information. That's concerning. That's concerning, because literally can't say whether he's actually still with IDOC. I don't know. Yeah.
I heard some of the audience feedback, and I wanted to tell you that I've taken it into consideration, and we are going to be launching another product, another piece of apparel, and it is marked down a little bit. It is a little bit cheaper.
Down a little bit.
Wait, who's on the? Nice. Love that. Love that.
That's pretty sweet.
Yeah. Oh wow!
Hit
Look at
me
that
up.
markdown. Look at that markdown.
Yeah, it's a huge price drop.
Huge price drop. If you thought you couldn't have one, now you might be able to own your own Riddler. ISP Superintendent Riddler.
I almost forgot.
Basically the true crime home shopping network now.
So I know they're 87 or they're 86.92 for one, 84.25 for the other. We have a little bit of a deal going on, and it's two for 165. So
Nice. I mean, well, you can't pass up that deal. That's the deal of a lifetime, people.
Yeah.
What are you doing? Call the toll-free number right now.
I mean, we're losing money on that deal.
Get in before these are sold out.
Yeah.
Yeah, they're hot right now. And it says really? Diddler or not Diddler.
This is
Riddler.
Summer's hot item. Like if you're going out to the club, if you're going to church, like,
yep.
Like this is the apparel.
You're going to a trial.
Yeah, you go to the trial.
Can you imagine if we wearing the Riddler t-shirt? Would they let me in a Riddler t-shirt?
No.
You probably get arrested for having something that resembles a badge.
I tell you that absolutely not let you in.
They're not letting me in regardless. Certainly not in a Riddler shirt.
Oh, you ain't fucking getting in it.
I'm not getting it. Are you kidding me? Keep fucking dreaming, toots. No fucking chance. I'm surprised they left Courtney alone.
I'll be there and I'll see it. If you guys see me, say what's up.
I went to the Supreme Court and I was like, I'm wearing like an eagle with like an American flag. Is that a political statement? And they're like, that's fine, actually.
Actually, you're good. You're fine. We'll allow it.
It's like I don't know how strict you guys are. You're like,
yeah, she would definitely throw me too. Well, Fiend, I think that we should wrap it up here.
Okay. It is your channel, so you can do what you want.
Yeah, I think we
unless DB comes back, then it's DB's channel.
Then it's DB's channel. Yeah.
I don't know. He might have another shirt. You think there's a third shirt?
It's I can't say. It's a toss up with that guy.
Somebody say third shirt. Nope, not yet. But we are working on some other products, and if you guys have any ideas for products you'd like to see in the future,
yeah, he's sifting through our focus group feedback. He's working on it. It'll be here soon, though. It'll be really good too.
I think there needs to be like a shirt with like the Avengers team. Like you got an electric werecat and a Mothman and Yellow Death. And then you got the handler, DB.
And a DB.
Yeah, the handler.
Okay.
Yeah. The guy pulling the strings. Maybe make him like the puppet master in the background.
Yes. Appropriate. Actually, that's perfect. Let's make that happen. In fact, I think we should make it happen. Keep up the Cleveland.
Somebody out there probably has some mid-journey skills that can do that.
Yeah. Hey, I like your little avatar, the color scheme. I like it.
Yeah, a random person on Twitter, like I followed them and then they DM'd me and they're like, "I made this for you." I'm like, "Well, that's weird, but
yeah,
it's great." And like, you know what? Now I'm gonna go ahead and use it.
Yeah. No, you get fans, not fans, but like parasocial, friends.
Well, I think this person was just doing that randomly, like it was completely unrelated to true crime or anything.
That's awesome. Well, okay. Thanks for hopping on, Fiend. I enjoyed our conversation. I hope that you have a good time in the wilderness. Do you have bear spray?
You know what? So that's a product I recommend highly to most people. Get yourself some bear spray, but I do not actually have bear spray.
Why? For political reasons. No. Why not?
What? Oh, I don't know. Just lazy. Also, I don't know. I did. You know what? I'll just. You know, the electric werecat is inside me. I'll just.
It's true.
Use my claws. It'll be fine.
Yeah, like they're gonna have to worry when they see you coming. Is pretty much. Yeah, that's good. He's like, I am a bear spray.
I wouldn't fuck with me. I'll just say that. I wouldn't fuck with me.
Love it. Well, be careful. Thank you, everybody, for hanging out. Thank you, DB, if you're still lurking on the StreamYard. Thanks for hanging out and helping me and hosting and counting to 150 for us. And we'll talk soon, everybody. Bye.